never speak about anything on Western.
As the code fraternity is trying to come to terms with the nullification of Wetangula's election by Justice Francis Gikonyo, the same judge dealt the coalition yet another blow. He has asked the Director of Public Prosecutions to initiate criminal charges against Wetangula for engaging in election malpractices. Court legislators have faulted Justice Gikonyo's call for Wetangula's prosecution, saying it was an afterthought. Otherwise, it should have featured in the initial ruling that nullified Wetangula's election.
In that judgment, the judge did not make any order directing the DPP or anybody else to investigate Senator Wetangula at all. The requirement of the law is that if anything is to be done, then that must be encompassed in the judgment itself.
It's a political judgment. It's not a legal judgment. It has got no basis in law whatsoever.
But revisiting the ruling, Justice Gikonyo ordered, and I quote, "Accordingly, the first respondent was not validly elected. His election as the Senator of County of Bungoma is hereby declared null and void. I allow the petition." End of quote. The words "I allow the petition" literally means that the judge granted the prayer of the petitioner as documented in the ruling if no specific exceptions have been made. One of the prayers of the petitioner, as recorded in page 3, part I of the ruling, says, and I quote, "The Honorable Court finds that the first respondent has committed serious electoral offences and order him barred from participating in subsequent elections for a period of at least 5 years, as the court may deem just and expedient." End of quote.
Affected the validity of the results.
By allowing the petition without any exceptions, the judge is deemed to have granted every prayer, including the one that sought to bar Wetangula from vying. But court legislators are adamant that the decision of the judge was politically engineered by their Jubilee rivals in a bid to weaken CORD leadership.
If at all Jubilee government has a hand in this, we are warning them they should keep off and leave the people of Bungoma to choose their own senator.
We are putting this to the court of the people. Because if the judiciary is manipulated, then chances of getting justice there are very slim.
The leaders wondered why the judge wants Wetangula charged even before an appeal he filed against the ruling was determined.
When an officer of the court acts without any cause the way the judge has done, there is clearly opening himself to being placed under a tribunal to investigate why he's conducting himself like that.
Hii inaenda kuwa Makueni reloaded.
If the court decision stands against the appeal, then it will thwart Wetangula's bid to defend the seat he has occupied for at least 6 months. By extension, this would mean that none of the principals of CORD coalition would be in any elective position. The coalition had attempted to bring back either Kalonzo or Raila Odinga to any of the houses of the bicameral parliament soon after they lost the presidential elections, but such efforts died in futility. It is now for the Director of Public Prosecutions to determine whether there is reason to prosecute Wetangula, a determination that could also change his political fortunes in the future, depending on the angle it takes. Kendagor Obadiah, Citizen Live at 9, KICC, Nairobi.